Today, we are going to look at the immigration rate at Hyundai and LG and Seoul's battery plant in Georgia, the largest single-site enforcement action in U.S. history. More than 300 South Korean workers were detained. After about a week, today, they are finally on their way back to Korea under what has been described as voluntary departure. This all comes just weeks after the U.S.-Korea summit and Seoul's $350 billion investment pledge in the United States. To help us unpack the legal and policy implications, I'm joined by Kripa Upadhyay, a counsel lawyer at Buchalter, who specializes in immigration, foreign direct investment, and trade compliance. Kripa, to begin, could you give us a short overview of what happens legally when someone is detained for being in the U.S. without proper status? What are the main steps from detention to paperwork to possible outcomes?
Sure. I'm happy to address that. First of all, thank you for having me. I'm honored to be here. One thing I do want to be very careful about is information about exactly what happened at the raid is still coming out. So first things first, I don't agree that everybody that was arrested was necessarily out of status. Right? I think there is confusion as to what the visa status is that they had and what the visa status allowed them to do versus what the US government is alleging that they actually did. Right? So I think that's different. Historically speaking, if somebody is in the United States undocumented, or if they came in on, let's say, a tourist visa and that visa has lapsed and they have now continued to remain in the United States, if they are arrested, they are typically processed and then taken to an immigration detention facility. At that facility, they can then ask for what's called voluntary departure, or they can go in front of a judge and ask for immigration relief. Voluntary departure generally sometimes will require the individual to provide for their own airfare, but otherwise the US government will essentially just put them on the first available flight, and they are then repatriated to their home country. A voluntary departure includes with it a bar against re-entry into the United States in the future, right? So typically that is what happens. There is a due process option. There is a process that is meant to be followed, where you go into an immigration detention center. If you are afraid of going back to your home country for whatever reason, you can seek asylum. If there are any other forms of immigration relief that are available to you in immigration court, you can ask for that, but you can also ask for voluntary departure.
Okay, you said a lot in there. So the next question. So in that process, what legal rights do detainees actually have? For example, do they get the right to consult a lawyer? And how does that play out in the practice? Like, we've heard that many migrants, especially Hispanics, are deported quickly before ever speaking to an attorney. How does the law treat this?
Yes, so unfortunately, right to counsel is not guaranteed in immigration law because these are civil proceedings. The US Constitution guarantees right to counsel in criminal proceedings, but immigration law are civil matters, so there is no guaranteed right to counsel. There is no guaranteed right to an attorney. You can certainly look for an attorney and hire an attorney on your own or through family members or friends. I mean, I and several others are part of different organizations where we will provide free or pro bono consultations at, detention centers under certain circumstances, but there is no inherent right to free representation in civil proceedings, including in immigration proceedings. And that is something that immigration attorneys have talked about for a very long time. Unfortunately, it's not something that has necessarily changed in terms of US policy. In terms of whether you are removed immediately or expressly also depends on what your specific circumstances are, right? So for example, if you are arrested as you are attempting to enter the United States illegally or through a unrecognized border, then you are able to be removed immediately under what's called expedited removal. But if you were admitted into the United States, right? So you came in through a legal border, you had a visa when you were admitted into the US, and you were admitted into the United States, Typically, expedited removal is not something that happens without you having the opportunity to go in front of a judge or at least to be told what your options are and what your rights are.
That was a really nice overview of, what really matters and how the process works out. So now zoning into Georgia case. So in this case, it ultimately took about a week before the detained workers were able to return home. What caused that delay and what were the main challenges behind the scenes?
So again, typically when somebody is taken into custody for immigration proceedings, there is what's called a notice to appear that is issued. There is also a I-213, which is a form that immigration enforcement uses. The notice to appear is required because it informs the individual of what the legal charges are against them. Right now, again, I haven't represented these individuals. I don't know what those charges are. Based on what I have heard of the raid and of the people that were working there, my sense is that the charges against them was that they were authorized and admitted to enter into the United States either on ESTAs or on B1s, temporary visitors, but that they were doing work that was not authorized under that specific visa category, right? And so the charge would have been that they had violated status.
Mhm.
And because there was a violation of status, they were now removable from the United States. Because they were in custody, again, the US government takes time to find a flight and get them on planes, which I understand in this case was expedited, and I may be wrong in that, but I believe it was expedited because the government of Korea, my understanding, is provided a commercial airline for these individuals to be able to be expatriated back home. A week, unfortunately, is short. I
Oh,
know
wow.
of cases where
Mhm.
people have been in custody for months before there is a flight available and before they are able to be expatriated.
I see. Because yesterday, Koreans were supposed to go back home, but then there was this hold up, right? At first, news press said that there was some unspecific reason, like they couldn't figure out why. But then later, President Trump said, that if Koreans wanted to stay, they could stay longer, or there was some back and forth about it.
Yeah, but, and again, going back to what I said, right, there are some issues about the manner and the way in which this raid was conducted.
Mhm.
Again, for the most part, it appears that some of the workers, if not all of the workers, were
Mhm.
in fact in the United States lawfully. They may
Mhm.
have entered under, let's say, ESTA, right?
Yep.
The ESTA for work allows people from certain countries to enter the United States for temporary work, typically 90 days or less. And there
Mhm.
are certain restricted things that you can do lawfully
I see.
within that time, right?
Yep. Yep.
The raid also seems again, and now again, there's a lot of noise and a lot of communication and miscommunication about what happened here. There are reports that there was some sort of a call that was made. I believe a congressional Republican congressperson has taken credit for having called immigration
Yeah.
and asked for the raid. There's something about a labor union that may have called and asked for the raid. So there's all of this noise around this, right? I think what the comments from the president, I think what those point to is essentially what I'm saying is that these individuals were in the United States lawfully. They entered with visas. They were within the time authorized by the visas. There may be a question of was the activity that they were doing outside of what the visa immediately allowed them to do, right? That's a different issue from saying they were in the US unlawfully or that they were undocumented.
That's great. Yeah, let's move on to questions. So, from a legal standpoint, what exactly triggered the immigration raid at the battery plant? Was this a clear violation of visa rules, which we've been kind of touching on, or more of a selective enforcement choice by U.S. authorities?
I don't know that it was selective, only because, again, under this administration, they have made very, very clear that enforcement is a very big part of the agenda. There has been honestly no attempt to shield or to hide the fact that they intend to go after employers and employees who they believe to be in the United States illegally, or employers and employees who they believe are breaking the laws, right? And so I don't believe that it was selective. Again, like I said, there is a lot of noise with various people taking credit for having sent immigration to this particular site. I don't know what caused it, other than, in my personal opinion, you have a plant that is being built with foreign investment, and you have a large number of obviously foreign nationals that are employed at this plant. And some people may have thought that they were taking jobs away from US citizens, right? And that may have been the basis for the raid. But was it selective enforcement? I don't think so. That being said, I think there are definite issues about how this was conducted and the facts for individuals that were caught in the dragnet.
So you touched on the visa categories. I wanna ask you more on that. So many detainees reportedly enter under ESTA, as you know, the visa waiver program, or B1 business visas. Why are those categories especially risky when you're bringing in technical staff for large projects? Where is the line between legitimate business activity and unauthorized work?
It's a very, very fine line. And this is what I've, counsel my corporate clients, my HR, my foreign investors, anytime I have anybody coming into the US on an ESTA or a B1. Personally, I take a lot of pain to make sure that we are explaining to them what they can do and cannot do, right? So for example, the ESTA allows individuals to come into the United States for a period of less than 90 days. Typically, the activities that you are allowed to take part in are things like attending a seminar, attending a conference, speaking at a seminar. Now, if you're speaking at a seminar and you're receiving some sort of an honorarium in exchange for speaking, that
Yeah.
might be an issue. So you want to avoid the honorarium, but you can speak, right? You can come in to train employees, but not actually do the work that the employees are supposed to be doing, right? So
What
like
does that
if precisely. Now you understand the point, right? So if you are training somebody how to do a job, you're basically meant to stand there and explain to them how to do it, but not actually actively do the work yourself, right? So it's very
yeah.
restrictive. ESTA and B1 are both quite restrictive. The other issue I think that's come up specifically on this one, and again, I don't want to misspeak. I don't know what the timelines were. Under this administration, we are currently under a period of what this administration refers to as extreme vetting, right? What that means is that every applicant, whether they are applying for an ESTA or whether they're applying for a B1 visa, certainly, but certainly anything above that, right? Like an H1B or an L1, which is what other visas that would have been available to this company. Those are taking much longer to get at the consulates because every single individual is being subjected to extreme vetting. There are no visa interviews, which means every individual, even if you've been in the United States 50 times over the course of your life and you're now filing to come back into the US, you have to appear for an interview, right? And so the wait time has ballooned from, let's say, 3 weeks to maybe 3 months before you can even get a visa, which really severely curtails and impacts the amount of time and the planning, the front planning that has to be done by corporations to ensure they have that flow of personnel going back and forth, right? So I think that's where the ESTA particularly came in, is because the ESTA allows you to avoid the interview path, right? It's quicker technically to come into the US on an ESTA, but the work that you are allowed to do, the activities that you are allowed to participate in on an ESTA are quite restrictive. And I think that's where things may have gotten off the path on this one, is not that they were in the US unlawfully, but that the work that they were doing may have crossed over into paid, what is traditionally paid work, which is not allowed under the ESTA.
I think that's really clarifies what's the difference between these different visa categories here. So when I asked the first question, you mentioned about the voluntary departure and deportation. So we want to go into that. So the South Korean government has said the workers return under voluntary departure, while US officials at times use the word deportation. The Guardian also reported that at least one worker with a valid visa was still pressured into voluntary departure. From a legal standpoint, what's the difference between voluntary departure and deportation? And what does this outcome mean for these workers' ability to return to the US in the future?
So I don't know who from the US government is speaking. I will say, having been in immigration now for 17 plus years, officers for Customs and Immigration Enforcement, or the Immigration and Customs Enforcement, rather, ICE, are not generally lawyers. And so for them, every time they put somebody on a plane and send them back, it's deportation, and the difference doesn't mean anything, right? It's the language that is an issue. Technically, lawfully, legally speaking, voluntary departure means an individual agreed to leave the United States. They were not removed from the United States, meaning that any individual that received voluntary departure is absolutely eligible to reapply for a visa at any time, right? Is it likely that they will receive a visa? Likely not, particularly under this regime of extreme vetting. They would have to be able to show that there was a misunderstanding, a miscommunication, make some sort of a special appeal for the visa. But somebody that received voluntary departure is eligible to reapply for a visa. Somebody that received a deportation order, on the other hand, is technically barred from re-entry for anywhere from a period for 3 to 10 years, depending on what the terms and conditions of the removal were.
I see. So those who are on voluntary departure, they may come back to states.
They can apply for they can reapply for visas to re-enter, to return to the United States. Yes.
Okay, all right. So I want to kind of like zoom out a little bit and talk about some structural gaps in the institutions and policy here. So this incident seems to highlight some structural gaps in how Korean companies and their subcontractors manage US visas and labor compliance on fast-moving projects. From your experience, what practical steps can firms take to avoid this kind of problem in the future?
This is literally what I do on a daily basis, is counsel companies on how not to fall foul of the laws. I think understanding the different visa categories, making sure that your subcontractors, your HR, your attorneys, the teams that you work with to help with global mobility are very up to date on the changes that are occurring. Again, like I said, right now we are in a period where we have new immigration policy almost daily, certainly weekly, right? We have maybe 2 policies per week that are new, if not more. You have to work with somebody that understands what the changes are and what changes are coming, because we also have proposals that have been published in the Federal Register, and legally that takes 60 to 90 days before those become law, right? So that there has to be proactive involvement of legal counsel helping you decide which employee fits into which visa category, right? So if we take this case, for example, anybody that was coming to the United States to set up operations may have been fine to come in on an ESTA or a B1, temporary visitor. But there may have been some people that would have been better served coming in on, let's say, an L1 as an intercompany transfer or as an H1B. Yes, those are much harder to get, but that's where immigration planning becomes crucial. And you have to do this in advance, right? There is certainly cost factors involved with trying to get people that are able to do the planning and to help guide you. But I think making sure that you are working with a team that is aware of the different visa categories. What are the policies as they stand today? What are the proposed policies and how are they likely going to impact you? And what level of pre-planning can you do now to ensure that this doesn't happen in the future? That is absolutely crucial.
I think that was excellent, actually. I think really good guides for the future planning for the business people. So Do you think incidents like this could actually slow down or shift where Korean companies invest in the US? And are there historical cases where immigration enforcement discouraged other countries from investing? If so, what eventually reversed that decision?
I hope not. I hope that this incident doesn't cause governments, the Korean government or other sovereign governments to reconsider their investments in the US. Is it something that is absolutely going to impact decision making? Yes, absolutely. This is also not the first case. This issue about the use of ESTA versus B1 has come up before against companies, right? I know Disney was involved in similar litigation not too many years ago. There have been Indian technology companies that have also been involved in similar issues not too many years ago. I I work in immigration and international trade, and so unfortunately, these are very politically subject areas. And I try not to be political when I say this, but I will say that the focus on enforcement and the extent to which that happens ebbs and flows based on the government that is in power, right?
Mm,
Enforcement actions under Trump 1.0 were probably the highest that we have ever seen. Did that impact decisions by foreign companies in terms of if they were sending employees into the US or not? Absolutely. We saw significant amount of what I call nearshoring, where we
mhm,
were helping companies get employees into Canada or Mexico, as opposed to bringing them into the US, right? Unfortunately, it is obviously the US that ends up losing out in that deal. So I would say I hope foreign governments don't take this as a lesson and hold back on their funding. I fully expect that things might get later, might get delayed, because now they have to pay extra attention, if you will, to ensuring that they are sending employees over with the correct documentation and with the correct job descriptions and making sure people are doing exactly what that specific visa category allows for. And I think also, obviously, strengthening, tightening, having some sort of mechanism where you can ensure that the subcontractors you are working with are doing things the way they are meant to and being careful, right? I understand in this particular case, there were multiple subcontractors that were involved, that were supplying the labor, basically, if you will. And so you want to make sure that that's an issue. But this is not the first time that this
mhm,
has happened, particularly with the Ester and the B1.
mhm,
I would love to say that it would be the last. I don't think I think that's overly optimistic. I think as an immigration attorney, my only hope is, I will reiterate what I said for anybody that is seeking to expand in the US. There are so many opportunities for you to do that. I think it just requires you to work with counsel that is aware of what is happening and to engage in that pre-planning so you have the security of knowing that you're doing this correctly and you're not
mhm,
going to get caught in any sort of a surprise dragnet.
mhm, mhm. So you just mentioned special categories. So Australia has the E3, and then
Hmm.
Chile and Singapore have a H1B1, each negotiated in the early 2000s. From a legal and political standpoint, what would it take for Korea to secure something similar? And is that realistic even under the Trump administration?
I think so. I think so. I mean, and it's not just that, right? There used to be, at least when, I mean, and I'm probably dating myself here, but there used to be when I started practicing, there was a visa category called B1 in lieu of H1B. And
Mhm,
it's one that I used quite extensively for my clients, but that allowed somebody to come in on a B1 visa, but do work that would ordinarily be done by somebody on an H1B. But they weren't planning on staying here for 3 to 6 years. They were only planning on being here 3 months or so, right? All of a sudden, that sort of just fell away out of the visa options that are available because USCIS and the consulates at some point decided that that wasn't really working. They wanted people to be able to fit into this box of ESTA or into this box of B1 or into this box of an H1B. And again, I will say this, and I find myself saying this so much more nowadays, but the immigration laws in the United States haven't been revised, haven't been reviewed, haven't been revised since probably the 1980s. Right. So the system that we have today no longer responds to the global realities and the global economy and the global workforce that exists today. There has to be buy-in from all quarters, all stakeholders, national, local, regional, political, and otherwise, right? Business groups, certainly both the Democratic and the Republican Party and any other third party that cares to make their voice heard. But I think one of the other issues that we're dealing with is that unfortunately, the immigration system as it exists today no longer perfectly matches the realities of where we are in terms of a global economy and a global workforce. But until that shifts, you know, at the risk of sounding like a broken record, I think all companies can do is make sure that you are doing everything possible to work with counsel that can guide you, to come up with plan A, plan B, and plan C, and do the required amount of pre-planning to make sure that you're able to come into the US, establish your business, grow your business without being caught in a dragnet.
So, following up on that, so do you think that Trump administration's immigration policy will that make the U.S. immigration system better, or do you think it's going to be more like downgraded in one sense?
Well, if by downgrading you mean more stringent, then yes, we're
Yeah.
already seeing that. We're
Okay.
already seeing it be far more stringent than it was, right? So again, going back to the extreme vetting, for example, we are now at a point where Secretary Rubio has already gone on record saying very clearly, just because you got a visa to come into the United States doesn't mean we stop vetting you.
Mhm.
Right. So students, once they come into the United States, it's not like, okay, you have a student visa, you're good for the next 4 years. They are going to continue to monitor to the extent that they are able to, whether you are actually admitted into a university program that is accredited. Are you actually attending classes? Are you taking part in any activities that are deemed to be anti-American? Right.
Mhm.
And so if you mean are we likely going to see an expansion or a reimagination or a reconfiguration of immigration policy under this administration? No. I think it's going to be a period where we are more restricted and
Mhm.
enforcement is greater, which is why I think pre-planning and compliance is at an all-time high right now.
Gotcha. Gotcha. Okay, now moving on to the final question here.
Yeah.
So based on your experience in litigation and corporate immigration, what kinds of reforms, legal, regulatory, or through US-Korea negotiations could realistically prevent future clashes between immigration enforcement and major foreign direct investment projects?
So there are several issues, honestly. I mean, I do think that, individual governments, sovereign nations have the ability to work with the administration in terms of asking for specific visa categories. I mean, you mentioned the E3 and the H1B1. Given the amount of investment from the government of Korea and entities in Korea, I think that is absolutely something that would be ripe for conversation with this administration. Again, you have to understand that at least for this administration, from the very outset, they have been very, very clear about their belief that certain companies are engaged in what they call immigration fraud, because the belief is that foreign national workers are being brought into the United States to replace US workers. Right? We hear that language repeatedly in terms of H-1B visas, which is why there is again another effort now to redo the H-1B. And we're heading into H-1B season. H-1B registrations will start sometime in January. And so we expect that the H-1B regime will be changed between now and January. Right. But is there room for negotiation? Absolutely. Is there enough room for stakeholders, for companies, for technology, for health specifically, health-based companies to advocate for more categories and more visas and a loosening of restrictions or the creation of a system that is responsive to today's realities in terms of a global economy? Absolutely. I think in the long run, and it's not just me that's saying it, it's people, that are far more knowledgeable and far more expert at this that are saying this. But I think the risk that the US runs with the current immigration system remaining unchanged is that ultimately, maybe, 5 years down the line, we are going to lose out on talent that we need to keep within the US. Right. So I completely understand the need to strengthen borders and to have systems in place to ensure that people coming into the United States are coming in with the right purpose, if you will. But I don't think being this stringent and creating chaos in the workplace, honestly, with these immigration raids to the extent that they are being conducted at this point in time, is helpful for future foreign investment.
So is there, just before we wrap up, is there anything you want to mention or you want to say regarding the incident or to the Korean companies or Korean policymakers?
If I may, I will just say this, right? I would hope that this is not something that you take to say that, you don't want to invest in the US. I think there are plenty opportunities for you to be able to invest in the US. The talent here is extensive. The opportunities for growth are extensive. I think, again, compliance, and sorry to sound like a broken record, but I think compliance, planning both from immigration, international trade, controls, international trade policies, because those are also an issue with the tariffs and the trade agreements that are coming in right now. But I think having attorneys on the front end help you, guide you, building that relationship is crucial to making sure that you are able to get yourself established, get yourself established in a way that ensures you are able to grow, and that it is it is to the benefit of companies in Korea and the government of Korea as well as the United States. It's not going to be easy, but I think that's why you need to build relationships with counsel and with groups that are able to help be a resource and a guide. And it's not purely, you hire me for this case, so this is all I do. It needs to be a relationship that you build with these companies.
That was really great, Kripa. So thank you so much for sharing your insights today. This case has raised difficult questions about the intersection of immigration enforcement and international investment. And I know our audience, especially Korean policymakers and businesses, will take away valuable lessons from your expertise. We'll continue to follow how US immigration and trade policy evolve in coming months. But for now, thank you again for joining us.
Thank you very much. It was my honor to be here, and always happy to be a resource. Feel free to share my information. I am happy to answer any and all questions as and when they come in.
Thank you so much, Kripa.
Thank you.